Blake Jenson fired me where he knew it would hurt most. Right in the middle of the office, with everyone watching, like my mother's illness was a punchline he could use to prove he was in charge. Atlanta, Georgia. Tuesday morning. The client floor at Redwood Lane Claims was already buzzing, headsets on, dashboards glowing, when Blake strode into the aisle between our desks and stopped at mine. He didn't lower his voice. He didn't pull me aside. "So that's it?" he said, smiling. "You're leaving again for your mommy?" My stomach tightened, but I kept my tone steady. "I'm taking my approved caregiver leave. Her chemo appointment was moved up. I notified you yesterday." Blake laughed, loud and bright, turning heads. "Unbelievable," he said, looking around like he was inviting the room to agree. Then he leaned closer and delivered the line that made my face go cold. "If your mother can't survive without you, that's her problem. Stop making it mine." I could feel the room go still, people pretending not to listen, but listening anyway. Blake tapped a folder against my desk. "Clean out your stuff. You're done. I'm not running a charity clinic." I didn't cry. I didn't beg. I stood up slowly, picked up my bag, and walked out. Not because I was powerless, because I already had what would follow him into court, and I knew exactly how it would sound when a judge heard it. My name is Carissa Lane, and I was 37 years old, a caregiver, and the only person my mother had left who could translate her fear into action. She'd had a stroke last year, and then the cancer came like it was finishing a sentence. Her co-pays were $410 per infusion. Her anti-nausea prescriptions were another $78 each time. My rent was $120. My car note was $389. And my health insurance, covering both me and my mom as a dependent, ran through Redwood Lane. That job wasn't ambition. It was oxygen. I worked as a claims operations specialist, the unglamorous glue role that fixed what everyone else broke: documentation, compliance, escalations. My performance reviews were strong. My metrics were clean. I rarely missed deadlines. Until my mother got sick and my life stopped being convenient. When I disclosed my caregiver situation to HR, I did it the right way. Paperwork, doctor documentation, a request for intermittent FMLA leave, a few hours here and there for appointments and emergencies. HR approved it in writing. I kept the approval letter in a folder at home like it was a passport. Blake hated it the moment he learned it existed. The first time he cornered me about it, it was in a conference room after a team meeting. His voice was sweet and poisonous. "You know what happens to people who aren't reliable?" he asked, smiling. "I'm reliable," I said calmly. "I'm also an approved allowing caregiver under federal law." He laughed. "Federal law? You sound like you want to sue somebody." I didn't answer then. I just started documenting. Because Blake wasn't the type to be corrected. He was the type to retaliate until you gave up. And he escalated exactly the way men like him always do. Quietly at first, then publicly. He started scheduling my one protected afternoon appointment window with mandatory client calls. He told me to swap shifts with coworkers who were too scared to refuse. When I took leave anyway, he marked it as an unexcused absence in the scheduling system. I emailed HR with the FMLA approval attached. HR replied with a sentence that still makes my jaw tighten when I remember it. "Please work directly with your manager to align attendance expectations." Attendance expectations. As if the approval letter was a suggestion. The month before he fired me, Blake started building a story about me. He called it performance concerns, but it was really a smear campaign designed to justify what he wanted to do anyway. Remove the inconvenience. He wrote me up for lack of flexibility after I left at 4:30 to take my mother to the ER when her fever spiked. He wrote me up for poor attitude because I asked him to confirm in writing whether my caregiver leave would be counted against me. He moved my desk to the far end of the floor, away from the team, and told people I was distracted. I wasn't distracted. I was exhausted. I would finish my shift, drive to my mom's apartment, sit with her through nausea and shaking hands, then go home and fall asleep with my phone still in my palm because I was terrified I'd miss the next call. On the mornings after infusions, she'd whisper apologies like she'd chosen this. I'd smile, reminding her it wasn't her fault, then walk into Redwood Lane and pretend I wasn't breaking. Blake knew he could use that fatigue. 2 weeks before the firing, he called me into his office with HR on speakerphone, Lydia Graft, who spoke in a soft, careful voice like she was trying not to get anything on her clothes. Blake didn't waste time. "We're revoking your intermittent leave. It's disruptive." "That's not how FMLA works," I said, calm and precise. "You can't revoke it because you dislike it," Blake chuckled. "Watch me." Lydia cleared her throat. "Carissa, we want to support you, but business needs—" I cut in, still calm. "If you're changing my leave status, I need it in writing and I need the basis." Blake's voice turned intimate and cruel. "You're not special because your mom is sick. Everybody's got something." Then he dropped the line like he wanted it to bruise. "If you can't separate your personal drama from work, maybe you shouldn't be employed." That day, while he talked, my phone was recording in my purse. Georgia is a one-party consent state. I was present in the conversation. I didn't record for revenge. I recorded because I'd been watching reality get rewritten in real time, and I needed proof. After the meeting, HR emailed me a coaching plan. It was impossible by design. Improve metrics by 15%, take no unplanned absences, and be available for scheduling adjustments. In other words, stop being a caregiver or lose your job. I replied once, briefly, with the FMLA approval attached again. Then I saved everything. Email headers, calendar invites, the scheduling system screenshots, my own performance reviews, the write-ups with dates that perfectly matched my leave usage, and the recording, clean audio of Blake saying he was revoking my leave because it was disruptive. Then came the Tuesday morning when my mother's oncologist moved her chemo earlier because her blood work was trending worse. I notified Blake the day before, like I always did. I had the clinic's message in writing, and Blake decided that was his moment to do it publicly. He fired me in front of everyone, called my mother my problem, and told me he wasn't running a charity clinic. That afternoon, the termination email hit my inbox. Separation for attendance and performance. Benefits ending at midnight. COBRA available within 5 business days. When the COBRA estimate arrived, it was $1,276.20 per month. I sat in my car in the parking lot with my hands shaking so badly I couldn't start the engine. I thought of my mom's next infusion. I thought of my rent. I thought of how quickly "we'll be fine" turns into "we're not going to make it." And then I did the one thing Blake was betting I wouldn't do. I hired a lawyer. Not because I had money. I didn't. I had $2,300 in savings and a credit card already strained from hospital copays. But my lawyer, Reese Morgan, listened to my timeline, looked at the FMLA approval, read Blake's write-ups, and then asked a single question that made my throat tighten. "Do you have anything in his own words?" I slid my phone across the table. "Yes." Reese listened to the recording without expression. When it ended, he nodded once. "This isn't a misunderstanding," he said. "This is interference and retaliation," and he said it out loud. We filed a complaint. FMLA interference, retaliation, wrongful termination, and damages tied to the health coverage disruption. Redwood Lane responded the way companies do when they think they can intimidate, deny everything, attack my credibility, call me unreliable. Blake apparently couldn't resist performing even in legal settings. In his deposition, he laughed when Reese asked whether he'd ever referenced my mother's illness as a problem. "I might have joked," Blake said, smiling. "She was always too emotional about it." Too emotional. The same word men like him use to erase women's reality. Reese didn't argue. He just said, "Let's mark Exhibit 11. Then he played the recording. Blake's voice filled the room. Unmistakable. "We're revoking your intermittent leave. It's disruptive. If you can't separate your personal drama from work, maybe you shouldn't be employed. If your mother can't survive without you, that's her problem. Stop making it mine." Blake's smile froze. His attorney shifted hard. The court reporter kept typing, steady and indifferent. Blake tried to recover. Out of context. Reese's voice stayed calm. "What context makes FMLA retaliation legal?" That's when Redwood Lane stopped treating it like an employee complaint and started treating it like a crisis. A judge ordered a preservation hold. IT logs were subpoenaed. HR emails surfaced. Lydia warning leadership that denying FMLA could create significant exposure, and Blake replying, "I don't care. She's a drag on the team." The case moved to a hearing on sanctions because someone, Blake, had deleted calendar invites and tried to clean up the scheduling notes that showed my absences were approved leave. The deletion wasn't complete, though. Systems, remember. On the morning of that hearing, Blake walked into court wearing the same confidence he'd used on the office floor. He laughed quietly with his attorney like this was still a performance. The judge, Honneur Marcia Caldwell, didn't look amused. When Reese explained the deletions and played the recording again, the courtroom went still in that way that feels heavier than shouting. Judge Caldwell leaned forward, eyes sharp. "Mr. Jenson," she said evenly, "did you terminate Ms. Lane after she used protected caregiver leave?" Blake tried to smirk. "I terminated her because she wasn't reliable." The judge didn't blink. "Do you consider an approved FMLA absence unreliable?" Blake hesitated. "It created operational issues." "And your solution," the judge said, voice tightening, "was to revoke leave you had no authority to revoke, then terminate her in public?" Blake opened his mouth, then closed it. Judge Caldwell turned to his attorney. "Counsel, your client has testified inconsistently with recorded evidence and appears to have participated in spoliation. That is not a minor issue." Then she looked back at Blake like he was no longer a manager, just a man who'd finally met a boundary. "This court is issuing sanctions," she said, "and I am referring the spoliation and potential false statements to the appropriate authorities for review. Additionally, I am granting the plaintiff's motion for adverse inference." That one phrase, adverse inference, shifted everything. It meant the court could presume the deleted evidence would have been unfavorable to Blake and the company. It meant his joke had become a legal weight around his neck. The settlement came fast after that. Quiet, corporate, heavy with numbers. $980,000 total. Back pay, front pay, emotional distress, attorney fees, and a separate amount tied specifically to healthcare costs incurred during the coverage gap. My benefits were restored retroactively through the settlement period so my mom's treatment wouldn't collapse. And buried in the settlement structure was the part that ended Blake's career. Redwood Lane had to terminate him for cause as part of their corrective action plan with the board and insurers. His firing wasn't framed as restructuring. It was documented as misconduct tied to retaliation and evidence tampering. That kind of record follows you. Blake didn't get to quietly hop to another management role with a polished reference. He became the risk companies don't want. The liability. The name that makes HR departments go silent when they check background. I didn't feel triumph when I heard he was gone. I felt something quieter. Relief. My mother continued treatment without gaps. I paid down the credit cards that had been holding us up. I moved us into a smaller place closer to her oncology center, so the drives weren't another battle. And when I finally slept through a whole night, it didn't feel like rest. It felt like survival, finally loosening its grip. The biggest change wasn't the money. It was what I did with the lesson. I started volunteering with a caregiver advocacy group in Atlanta, helping people understand how to document leave, how to escalate retaliation, how to protect themselves before a manager's joke becomes a crisis. I stopped believing that dignity was something you had to earn from powerful people. Because here's the truth Blake learned too late. When you laugh at someone's sick mother, you're not showing strength. You're showing the court exactly who you are. If stories like this matter to you, stories where power is exposed, dignity is defended, and silence doesn't win, make sure you're subscribed to the channel. Every week, I share real, emotionally intense workplace justice stories like this one. Stories about people who were underestimated, pushed too far, and finally fought back in ways no one expected. Before you go, I want to ask you something. What did you feel while listening to this story? Have you ever gone through something like this? Or do you know someone who has? Someone whose health, dignity, or livelihood was treated as expendable? Share your thoughts in the comments. Your story might be the one someone else needs to hear.